Well, good afternoon, everybody, and thank you for joining Corin and I in relation to this talk that we've planned for you for this afternoon. The heading's Fundamental Dishonesty you've seen. It's going to be a bit of a whistle-stop tour, but we're focusing on a few core issues for you, hopefully. What we thought was the easiest to do to stop the flow, to prevent the flow of the talk ending, is if anybody's got any questions, if you put them in the chat box. And then at the end of the talk, we can deal with those if we have time. Also, there will be copies of the slides available if you require them. Victoria will have copies of those, so you can email her after the talk to request copies of those slides. Me and Corin and I have over 40 years, believe it or not, together dealing with fraudulent claims, principally defendant orientated, but we do a little bit of the claimant side as well, if there's anybody here for the claimants. So hopefully this will give you all a little bit of a insight into some of the issues that we think are more prevalent today on the issue of fundamental dishonesty. Thank you.
Thank you. Liz, can we bring up the first slide, please? I'll just, we're using Liz's laptop. That's lovely. I wonder whether.
There we go.
Excellent. Okay, we were nearly there. One more, Liz. Thank you. So, good afternoon, everybody. I'm Corin Furness. I'm a barrister at Park Lane Plowden, as Liz has mentioned, and it is a little bit of a whistle-stop tour. We've only got an hour or so to speak today. So a reminder at the very beginning as to what we're really talking about when it comes to fundamental dishonesty and its relevance, of course, in respect of costs under CPR 44 Rule 6, and perhaps more significantly for the purposes of today's seminar, where we've got any issue in respect of Section 57 of the Criminal Justice and Courts Act 2015, where a claimant who would otherwise be entitled to recover damages may face an application by a defendant to have their claim dismissed. So in a nutshell, Mr. Justice Ritchie described it as follows. There are 5 steps to be taken by the trial judge when faced with a defence under Section 57 before a finding can be made for fundamental dishonesty. First of all, has the defence been pleaded? Liz will address that shortly herself. Secondly, a reminder that the burden of proof when it comes to fundamental dishonesty lies with the defendant, and that's to a civil standard. Thirdly, there needs to be a finding of dishonesty by the court. Fourthly, the dishonesty itself has to be fundamental in as much that it's fundamental to the claim, and dishonesty relating to a matter incidental or collateral to the claim would not be sufficient for a finding of fundamental dishonesty. And also, the court can look at whether or not, if it is fundamental, whether indeed it does have a substantial effect upon the presentation of the claim. The court applies the test of dishonesty identified by their lordships in Ivy and Genting casinos. Again, I suspect many of you joining today are thoroughly familiar with that authority, and simply to highlight at this stage that there is a 2-stage test which needs to be applied by a trial judge. Firstly, to find as an evidence on the fact what the claimant's state of mind was at the relevant time of the relevant matters, and secondly, to apply an objective standard to determine and decide whether the claimant's conduct was indeed dishonest as alleged. And then finally, if the defendant is successful in proving those matters, the claimant has a burden and responsibility then, if he or she wishes, to allege and prove that there will be substantial injustice if indeed the claim is dismissed. So we are going to address 4 key issues today. Firstly, should fundamental dishonesty be pleaded? Secondly, is the dishonesty fundamental to the claim? Thirdly, when is there substantial injustice? And fourthly, what evidence do we need to look for and consider to either prove or disprove an allegation of fundamental dishonesty?
So the first question is, to plead or not to plead? That is the question. So it can often be quite difficult to consider or when to plead fundamental dishonesty. Obviously, each case is different, so we can't say yes, you should always plead it, yes, you shouldn't always plead it. There's various factors, as I've listed here, which you need to take consideration of, not just the case law, but from tactical perspective. So, for example, at the stage you're at in the proceedings, when you're drafting the defence, do you want to put the claimant on notice that you might be considering fundamental dishonesty? That may be particularly important if it's a high value claim and you may be thinking of getting surveillance footage in relation to this claimant. You may not want to think about pleading any inconsistencies or any points in relation to fundamentally at that point and keeping your powder dry, so to speak. I always think it's a good idea as well when you're pleading or thinking of pleading fundamental dishonesty to think, what is your aim? What's the end goal here? Are you trying to use this to get you're going to go all the way at trial? Is that your anticipation? Are you trying to scare the claimants off? Are you hoping for a discontinuance? So always a good idea to start with your goal at that stage. Obviously, the most important factor and one of the most central features is, have you got any evidence in relation to this? Have you already got some evidence from, we'll talk about evidence later on, but for example, Facebook entries which show inconsistencies or significant issues between the discrepancies between the medical evidence and photographs that you may or may not have changed. Have you already got your surveillance footage? So there's a lot of tactical considerations here. If all you have is a suspicion at the stage when you're pleading, you're probably better off keeping your powder dry to some extent, but that's still going to depend on the value of the claim and the nature of the claim, as we will see when we're looking at some of the case law. So we're all aware of Howlett and Davis. We've talked about that before. We've pleaded it before. It's a question of putting on notice, and most of the authorities which I've provided in these slides give the same idea. You need to give the claimant a reasonable opportunity to respond to the allegations, or certainly some of the factual points that you're putting forward in relation to why you are going to be asserting at the end stage that they're fundamentally dishonest. In particular, the low value claims, for example, the LVI claims, the low whiplash injury claims, judges will often be minded to say, and I certainly have had this on several occasions when it's not pleaded, well, has the claimant been put on notice of this? If I've got a bit of correspondence which shows that they've been put on notice, they know the allegations they're responding to, quite often that will assist. But some judges will take the view, depending on the correspondence, that they haven't been put on reasonable notice. Mustard and Flower is an interesting case in the sense of, at that point in time, when they were actually, in that case, seeking to amend the defence. So, of course, the court has an element of control when you're amending the defence, because you have to seek the court's permission in order to obtain such an amendment. So Master Davidson, in that case, didn't want to detract from the cards on the table approach and putting the claimant on notice, and giving that notice at the reasonable opportunity. But what he wanted to try and detract from in that particular case and try and discourage defendants to do was just to simply plead which in this case, and they did, or at least they tried to, they wanted to reserve the right to assert Section 57 and fundamental dishonesty at a later stage. And the judge considered that really, there was no benefit to that. And of course, when applying the test which he needed to in making the application, one of the questions was whether there was a reasonable prospect of success. Well, at the point when you've only got a suspicion, then of course there is going to be little chance in relation to that, because there's very little chance of a reasonable prospect of success. So suspicion potentially is probably not enough if you're amending the defence. Pinkerton Direct Line is another interesting one. In that one, it was a counter schedule in which they were pleading. That seemed to satisfy the court. They raised specific allegations in the counter schedule of gross exaggeration, etc. And one of the factors that the judge considered in that case to be important was that the claimant had got the reasonable opportunity still to respond to those allegations in the counter schedule. They could have put further witness evidence in response. They could have gone and got further medical evidence or sought questions and sought permission to rely upon that. So it wasn't just a case of an ambush, shall we say, in the old terms, from the defendant. It still gave the claimant the opportunity to put their case and respond in relation to that. This was a high value case, Pinkers, of course, with the surveillance footage included within that. Jenkinson and Roberts, again, just really emphasises the point. Mr. Justice Chowdhury is an example of a court overturning a finding of fundamental dishonesty. This case was against a litigant in person. And the claimant had not, it was considered the claimant had not been given adequate notice of the allegations to respond. The judge at first instance had made a finding of fundamental dishonesty. But in that particular case, it's quite interesting that quite a lot of the points that the judge found fundamental dishonesty in relation to hadn't even been put to the claimant in cross-examination. There was reference to the Howlett requirements of adequate notice and giving an opportunity for the claimants to respond, as we've already discussed. Again, that notice being a crucial element in giving the claimant the opportunity to respond seems to be central to these features, going back to the case of Howlett. So in cross-examination, it seems as well that these matters need to be specifically put to the claimants in order to get home on an allegation of fundamental dishonesty. More recent case, very briefly, in the case of Williams, Henry and Associated British Port Holdings. We'll come back to this case again later. Mr. Justice Ritchie clarified his position because, of course, in Kajanu, he'd used the words in relation to pleading section 57 that it should be pleaded. He detracted from this a little bit in this case, he said it must be pleaded. He detracted in this case and said it should be pleaded, and therefore it didn't matter if there was no pleading, as long as it had reasonably, if it has reasonably only arisen late, it could still be put forward, could still be pleaded. Again, in this case, the defendant raised the allegations in a counter schedule, and that gave the claimant still a reasonable opportunity in order to put forward its case and respond to those allegations. So even in relation to section 57, the guidance seems to be, again, depending on the value of the case and the circumstance of the case, it should potentially be pleaded, but it's not a complete bar. But of course, if you're dealing with a surveillance footage case of a high value, the burden is probably going to be more on you, or if you're the defendant, to plead and raise those specific allegations that you are relying upon in order to give that claimant specific notice. And in some respects, although you're giving them that notice, it bolsters your case, because if you're pleading them, it might be from a tactical position, for example, at the counter schedule, you're raising these points and really trying to show the claimant that you mean business.
Thanks, Liz. I'm going to concentrate on one particular case, which is Boyd and Hughes, which is a recent case of Mr. Justice Cotter. It's a decision of the 28th of February 2025. I'll give the neutral citation in the slides, but in fact, it's also reported at 2025 PIQR P11. In that case, Mr. Justice Cotter conducted a very thorough overview of relevant authorities about what was fundamental, the purposes of an allegation of fundamental dishonesty. And before I address some of his observations, which have a wider relevance, I'm just going to describe a little bit about the case itself. It was perhaps an unusual case for the purposes of FD. It was an Animals Act case. The claimant was employed by the defendant as a work rider and stable hand, and the defendant was a racehorse breeder. And during the course of her employment, the claimant was exercising Foxy, a 3-year-old thoroughbred gelding, on the gallops, during the course of which the claimant was thrown from Foxy and suffered a nasty injury to her right arm. The claim was defended principally on the basis that the Animals Act had no application and there was no foundation for a claim of common law negligence. But also, the defendant made an allegation of fundamental dishonesty, principally on the grounds that there was a dishonest exaggeration of the level of disability and the claim. The claim was dismissed by the Justice at first instance. And what Mr. Justice Cotter said at paragraph 259 of his judgment is this: after some significant hesitation, I've concluded that the effect of the dishonest exaggeration was not sufficiently significant to mean that it went to the root or heart of the claim. It was a dishonest embellishment in an attempt to underpin an essentially honest claim. The claimant should consider herself fortunate that her conscious exaggeration has not had devastating consequences. In the end, it is the extent of her voluntary information, pre-disclosure of surveillance evidence, and the limited potential impact of the damages claimed that has persuaded me by a narrow margin that the defendant has not satisfied the burden of establishing FD. So even though the claim was dismissed on the grounds of liability, the judge drew back from making a finding of fundamental dishonesty. And what the judge did during the course of what was a very thorough review of the relevant authorities is that he identified really all the cases that we'd expect to find and consider, starting with the case of Gosling and Halo. And that's the decision of His Honour Judge Maloney. And no doubt you're familiar with the words which he identified in particular, where he referred to there being a substantial or important part upon dishonesty itself, and looking at the root of a claim and whether the dishonesty goes to the whole or substantial part of the claim. That particular observation was approved. Lord Justice Newey in Howlett and Davis, the Court of Appeal case from 2018, describing that analysis as simply common sense. But what Mr. Justice Cotter did in the case of Boyd was then review other authorities and compare and contrast those observations and interpretations by a series of judges with the decision in Howlett and Davis. That included a review of Mr. Justice Friedman's interpretation of Section 57 of the Act in Denzil and Mohammed. It also included a review and consideration of Lowcock and Sinfield, and in particular Mr. Justice Knowles' statement, well known, I'm sure, to most, if not all of you, that when considering whether a claim is fundamentally dishonest, the court looks to see whether it substantially affected the presentation of the case on liability or quantum in a way which potentially adversely affects the defendant in a significant way. In Boyd, Mr. Justice Cotter then referred to Mr. Justice Knowles' review of 3 first instance decisions. That's Meadows and Latasca, Rayner against Raymond Group, and Menery against Darton, and used those as means by way in which he could identify cases which pointed towards or away from a finding of fundamental dishonesty. So was it used to bolster an honest claim? Was the dishonesty peripheral? Was it simply a concealment or an exaggeration which often accompanied personal injury claims from time to time? Mr. Justice Potter also reviewed the case of Elgamal, and you have further details set out there on the slides, which will be forwarded to you if you make those inquiries with Victoria Steele following the conclusion of today's seminar. I won't read those out in full, but in my judgment, Elgamal sets really a very high bar for a defendant. And in my judgment, what Mr. Justice Jacobs did is forgive a claimant a level of dishonesty which other justices, in my experience, would not have done. Dishonest exaggeration was not a fundamental dishonesty in the context of that particular claim. What Mr. Justice Cotter also did is he reviewed his decision in Mayepa, which was one of his early decisions in 2022. And in that case, he identified a series of questions, 3 questions, which he thought might be instructive when considering whether or not dishonesty has been fundamental. Firstly, at what stage and in what circumstances did the claimant's dishonesty start? Secondly, does the dishonesty taint the whole of the claim, or is it limited to a divisible element of the claim? Thirdly, what was its effect upon the value of the underlying valid claim when compared with the inflated claim? And Mr. Justice Cotter also approved the observations of Mr. Justice Friedman in Denzil and Mohammed, reminding the courts that the word fundamental should be given its plain meaning. It's a straightforward jury question to be determined by the trial judge, And it's often a holistic exercise whereby the judge conducts a comparison of the value of the genuine claim when compared with the value of the dishonest claim advanced by the claimant. Mr. Justice Cotter concluded, perhaps somewhat unhelpfully, as follows at paragraph 237 of his judgment. I respectively agree with this analysis, as I set out in my upper, at the committee stage of the passage of the Criminal Justice and Courts Bill through the House of Lords, Lord Foulkes, Kearns Counsel, conceded that the adverb to qualify a concept such as dishonesty is not linguistically attractive. But it sends the message to a judge who, as a result, will know exactly what the clause is aimed at. Rather than set out a detailed description of an elephant, Parliament has clearly trusted a judge to know one when he or she sees it. So, when is it that the judge will see the elephant, in the courtroom or perhaps in the witness box? It's a question of fact. It's a question of degree. It's a jury question. It's a binary question. And judges at first instance have addressed this matter in slightly different ways over the last 5, 6, 7 years since Section 57 has been enacted. Relevant matters, from my perspective, would include the following. Does the dishonesty taint the entire claim, or is it simply a divisible part of the claim? In my experience, if it taints the entire claim, it is easier for a defendant to prove its allegation that the dishonesty is fundamental. A key issue is the value of the dishonesty. In my experience, it would assist judges to take them through a baseline of what the proven claim will be worth, a step-by-step approach, often by reference to a chronology, and compare that with the level of symptoms which are underpinned by the alleged dishonesty. Look at the heads of loss individually, look at the value of the claim individually and collectively. Is there a significant disparity between the two? What also has been the duration of the dishonesty? Is it a case where that dishonesty has been maintained throughout the litigation? Has it been maintained through pleadings, medical reports, statements, CPR 18 replies and the like? Has the claimant sought to give an explanation for dishonesty? And indeed, in the case of Sinfield, that's precisely what the claimant did. I'm afraid it didn't impress Mr. Justice Knowles, and he made a finding overturning the decision at first instance that indeed the claimant had been fundamentally dishonest. Also, what impact has the conduct had upon the claim in the litigation? For example, has it hijacked the trial? Has it hijacked the hearing? Whilst it's not specifically identified in some of the authorities, my judgment is that in the case of Sinfield, the test used by Mr. Justice Knowles dovetails with the submission that in fact where the dishonesty of a claimant has a significant effect not only upon the value of a case but on the way in which the claim has been litigated, that is a relevant consideration for the purposes of a finding of fundamental dishonesty. On this slide, I set out a series of examples and different circumstances in which courts have been prepared to find or not to find dishonesty as fundamental. One I haven't mentioned there is perhaps a more obvious one, which is where a claimant cannot prove and is proven not to have suffered an accident or injury at all. That is clearly fundamental. The case of Swift and Mars City PLC is a first instance decision of His Honour Judge Walsh. It's an O&L case. And in fact, what the claimant alleged is that she tripped over a curb. That was inconsistent with some of the other evidence in the case, in particular medical records. And the court wasn't satisfied that the accident happened as she described, thinking it more likely to caused perhaps by reference to tripping over a basket of washing. Either way, what the court was satisfied is that at the time the claimant advanced her case, she did not genuinely believe that she tripped over the curb. As a consequence of that, there was dishonesty, and it went to the circumstance of the accident and was therefore fundamental to the claim. The case of Congenou was a clinical negligence case. In that case, the claimant lied to the defendant about the circumstance in which he suffered an injury. He then sought treatment, which was conducted by the defendant. In that case, the defendant alleged there was fundamental dishonesty because the claimant had lied about the circumstance in which he'd been originally injured. In fact, upon investigation, it transpired the claimant was injured during an attempt upon his wife's life, for which he was subsequently convicted. But that was collateral to the claim, and therefore not fundamental to the claim, and there was no finding of fundamental dishonesty by the judge in that case. Beale and Tomlinson is an interesting case. That's a noise-induced hearing loss case. And the fundamental dishonesty arose really out of the claimant's false allegations relating to breach of duty. So although in that case, His Honour Judge Tyndall was satisfied there was a breach of duty by the defendant, the claimant, who had lied about whether he had access to PPE, in particular ear protection, the judge considered that that was a lie which was fundamental to the case because it was used by the claimant to bolster his prospects of success in the case. The judge was also satisfied that the claimant had lied in respect of his previous hobby of shooting, which he hadn't declared to the medical expert, and also as to whether it had a previous hearing test. Those matters, so far as the judge is concerned, were fundamental and were used as a basis to dismiss the claim. I was involved in a case a year or two ago in the Northeast, an employer's liability case where, amongst other things, the claimant, who alleged she suffered injuries to her eyes in a workplace as a consequence of dust generated by woodworking machines, alleged that she'd reported the accident at the time to her employer. The judge found that she had not done that, and the judge accepted my submission that that was a dishonest attempt by her to bolster her prospects of success, and that was one of the reasons in which the judge found that her dishonest reporting of the accident was fundamental to the claim. Dishonest exaggeration of symptoms. Here, the courts often look at whether or not it tainted the whole claim or a self-contained divisible element of the claim, and I cite there a series of cases where the courts have wrestled with that. My experience, where it's a divisible element and where that element is for a relatively low value, then in those cases, the courts are less likely to make a finding that any dishonesty is fundamental. But where the claim is tainted as a whole, those circumstances, it's much more likely the court will make that finding. In Elgamel against Westminster City Council, there was a claim for loss of earnings, but the judge was satisfied on the evidence that the claim failed because of want of proof. The claimant, who was actually a stuntman, sought to claim a difference in loss of earnings based on his prospective earnings as a stuntman. But in fact, the judge was satisfied that claim failed, not because of the claimant's dishonesty, but because the claim was simply not proven. And therefore, there was no finding that that dishonesty was fundamental. Claim for services in Lowcog, again, it's a case which is well known. The dishonest claim for gardening services amounted to some 28% of the value of the claim overall. For the purposes of that particular case, the court was satisfied that that was fundamental. In Williams, Henry and Associated British Ports, a case that Liz has already mentioned, reference there and dishonest inclusion of details for a life assurance application and dishonest representation of disability for the purpose of a DWP application were incidental, they were collateral, and whilst they affected the court's judgment of the claimant's credibility, they were not fundamental to the claim, and therefore in themselves there were no reason to make a finding of fundamental dishonesty, though the judge was satisfied in a very damning judgment for the claimant and the claimant's mother that the claim was fundamental dishonesty due to a series of lies and fundamental lies, which each of those had told during the course of the litigation. Finally, a situation which we regularly encounter, it's certainly in Road Traffic Act cases, where defendants will allege that cumulative inconsistency is sufficient by itself for a court to draw an inference of dishonesty. That's really a case or circumstances which are very fact-specific. Case of Peg and Webb and Melody and Cambridge Vibration are well-known cases where the courts have been prepared to find that where there are a series of inconsistencies, failures by a claimant to report previous accidents, failure to set out the detail of the claim properly in a series of documents, that cumulatively the proper inference not only is for dishonesty, but that is a fundamental dishonesty. Thank you, Liz.
Hello. This next section that we're going to move on to, of course, is going to be limited to just section 57. It won't apply to CPR 44 because something which is transpiring in some of the most recent judgments over the last few years is how and if under section 57 the claimant can still be awarded its damages, or at least some of its damages, on the basis that to prevent the claimant from having any of its genuine damages that the court considers to be genuine, of course, it has to assess those under section 57. Will that cause the claimant a substantial injustice if the judge dismisses the claim in its entirety under Section 57 and doesn't allow the claimant though that genuine element of its damages. Now, in relation to the London Organising Committee case, that was the first one that we all saw where Mr. Justice Knowles considered the issue. He brushes over that, I think, in his judgment a little bit, because the essence seems to be there's got to be something more than the claimant just simply losing the potential for example, £100,000 worth of genuine damages when maybe they were claiming £900,000. And there's got to be something, he seems to suggest there's got to be something more than that. Because he interpreted Section 57 as being quite penal in nature to the claimant. And clearly thought that that was what Parliament intended. In other words, if a claimant was being dishonest, they should be deprived of those damages simply because of that. So there's got to be something more, in his opinion, simply than the loss of those damages, the consequence of those that genuine damages because of the dishonesty. There's got to be something more of that, in his opinion, for there to be a finding of substantial injustice and the claimant still being able to recover the extent of those damages. Now, we then get a case which is a little bit more closer to home in Manchester, Idden and Warner, which is an appeal. His Honour Judge Sefton QC, sitting in the High Court, considered again the issue of whether or not there was substantial injustice to the claimant. This again was a high value case, and indeed in that particular case, the claimant had got a breast cancer diagnosis. But unfortunately, because it was diagnosed late, there was a delay there, and she had to have a mastectomy. It was thought that that wouldn't have occurred had it, well, she proved that it wouldn't have occurred and there was breach of duty. The NHS accepted that, or at least the doctor did. But going to the genuine nature of the claim, clearly there was a genuine claim there. But unfortunately, what the claimant did was she said that she wasn't running, she wasn't undertaking races like she used to. And of course, the defendants then discovered by doing a trawl on the internet that her name was registered on those races. However, she then did not confess the lie at that stage until the defendant then produced photographs of her actually competing in these cases. Initially, she'd said that one of her friends had actually undertook the race for her. So she was actually getting other people embroiled in her dishonesty by saying, look, this is my friend, you know, she's going to give evidence, she's going to say that she undertook the race for me, as well as her husband. So she was embroiling other people into this these continuing lies that she was saying. And it wasn't until the actual photographs that were provided, when she was constantly changing her case and trying to justify her position and the lie, and that she then gave another excuse, and that was because she was having to take cannabis oil, and she was before each race, and she was worried about being prosecuted. So there wasn't just one lie here, there was a cumulative effect in relation to those lies, and also getting other people involved. And that's something which the court took into account in this appeal, and considered that to be most serious and very grave in relation to her dishonesty. And there's a quote there: in my judgment, the culpability and extent of her dishonesty far outweighs any injustice to her in dismissing her claim. The dismissal of this claim seems to me to be exactly the evil to which Parliament directed its mind. In other words, the fact that they've been dishonest, they need to be, the claimants need to be punished in some way. And by taking those damages off the claimant, that is the punishment which Parliament intended. So in that case, there seems to be a start, I would suggest, of this balancing up in relation to what the actual dishonesty was, and the effect in relation to the claimant's damages being wiped out. Again, in the case of Woodger and Hellas, there's this idea again seeming to develop, shall I say, through the authorities, that this is going to be considered to be a balancing exercise. And that seems to be, again, the situation in Woodger and Hallas. Another case where there was exaggeration of injuries alleged in relation to fundamental dishonesty based on the surveillance footage which was provided. And again, the judge approached the question of substantial injustice by balancing, on the one hand, the nature and extent of dishonesty and the injustice in relation to dismissing the claim. And Mr. Justice Knowles again confirmed that there needed to be something more than simply the claimant's damages being extinguished in order for substantial injustice to actually be proven in that particular case. Now, I said we'd get back to the case of Williams Henry associated with British Ports Holding. This is particularly relevant on this issue of substantial injustice. The judge in this case, Mr. Justice Ritchie, goes into some detail in relation to what he considers to be the position in relation to what is considered to be substantial injustice. He says there is a two-part question. The balancing on the one hand and the nature extent of Mrs. Idden's dishonesty, and on the injustice to her dismissing the whole claim. So going back to Woodger, sorry, forgive me, I've not put the next slide on. So we're looking again at the exception in section 52, and he thought it's in the discretion of the court, judge's discretion. So of course we always find when we're dealing with anything that's in discretion, you can get conflicting judgments, difference of opinion. But this High Court judge, Mr. Justice Ritchie, thought there was a two-part stage here. One, finding of injustice to the claimant, and that injustice to the claimant would be substantial. So again, two questions to be asked and two questions to be considered. Again, Mr. Justice Ritchie, my interpretation of the judgment considers that the correct approach is to balance all the facts, factors and circumstances. And of course, once we're getting into the realms, once again, of discretion, looking at the facts, the circumstances, the factors, we're now getting into the realms of every case being fact specific, and that there are certain things we can point to and put into the mix in a lot of cases, but we're looking at the discretion. So it's going to be, in some cases, maybe difficult to predict. However, he has been reasonably helpful, I would suggest, because Mr. Justice Ritchie has provided a list of some of the pointers which he considered to be something that we need to look at, or at least the court should be looking at if the claimant is making a plea of substantial injustice in these cases. What Mr. Justice Ritchie, interestingly, if you read the judgment, did consider, however, was that he thought you could not just simply ignore the fact that the claimant was going to lose their damages, because in order to consider the point about substantial injustice, by the very nature of the fact, if you're considering substantial injustice, he made reference to the blindfold. And by making reference to the blindfold, what he seems to be suggesting is, when you're considering all these factors, the factors all relate back to the fact the claimant is effectively going to be potentially losing all the genuine damages that they should have been entitled to. So you can't just simply ignore the fact that the money is being taken away. You have to consider what the injustice is to the claimant. In other words, if the money is being taken away. So in looking at those factors, there is a list here that I provided on the slide. One of the main factors I would suggest is the ratio of the amount claimed to the amount awarded for the genuine injury. Corin has touched on that as well in relation to whether or not the dishonesty is fundamental. So if you're dealing with a £300 travelling expenses, for example, claim, in a claim where the genuine injury is worth £800,000, then it may be considered that the dishonesty in relation to those £300 travelling expenses, perhaps it would be disproportionate, shall we say, when looking at that ratio, and it would be a significant injustice to the claimant to simply dismiss the whole claim on that level. The scope and depth of dishonesty. Is there a discrete element to dishonesty? again, you might go back to the London Organising Committee case and consider the discrete element there, of course, was the loss of the care and the dishonesty related specifically to the care and assistance award. Did that taint the other matters? Was it just simply limited to that specific fact? Specific element of those damages? Or is it going to taint the whole element of the claim? That's a significant factor because, as Corin has already said, if the whole of the claim is tainted because the claimant's credibility is completely shot, then it's going to make it much more easier to say to the court that there is no substantial injustice to the claimant because the claimant knew exactly what the claimant was doing. The effect of the dishonesty, this is an interesting one, I think, on point 3. The effect of the dishonesty on the construction of the claimant's claim and destruction of the defence of the claim by the defendant. Now, this something is potentially something which a claimant themselves probably wouldn't be aware of, because the judge seems to be, in those circumstances, be looking at the effect on the costs. Has the effect of the dishonesty made the costs rocket? Has it gone from a 1-day trial to a 2 or 3-day trial as a result of the claimant's dishonesty? They're the factors which the judge appears to be referring to there. And of course, to the normal claimant who has no idea of the litigation process, or some of the claimants who don't, of course, we've got the serial claimants, but those claimants that have no idea of the litigation process, the effect there in relation to point 3 is something which, of course, is not actually within their mind. Scope and level of the genuine disability, potential increased burden on the NHS and the taxpayers. This is an interesting point as well, I would suggest, because the judge, when considering this element, seems to be of the view that if the claim was dismissed, and seems to be referencing that more to the care claim, for example, in a very high value claim where the claimant might need care for life, is it right that that burden should then be, if the whole of the damages are extinguished, should the burden therefore be on the NHS to deal with the care, to pay for that care and assistance that the claimant may need for the genuine element of that injury? Is that right? Because, of course, that puts the burden on the taxpayer, an increase on the NHS, when, as the judge put it, something along the lines of, well, the insurance company has paid the premium, why should the claim not be made on their funds? Nature and culpability of the defendant's tort. Again, there seemed to be a shift in relation to if it's a sexual abuse case, if the claimant's been prolonged, the result is a prolonged element of sexual abuse, there may be more, shall we say, sympathy for the claimant, as opposed to the situation where the claimant has been injured as a result of a momentary lapse of concentration in a road traffic accident. And I suspect that could same apply to an employer's liability case where maybe he's been working with a companion and something just simply happens and it's just simply an accident. So the nature and culpability of the defence tort is something to take into account. The effect on the damages due to paying out costs. Again, this is another interesting one, which I suspect the claimant would probably not have been aware of at the beginning of the claim until fundamental dishonesty is being put on notice and out there potentially. And that is the way the judge seemed to be describing this in the judgment is the genuine amount of the claim. So say, for example, the judge found £100,000 worth of the damages to be genuine. Is that going to be extinguished in any event through paying out on interim payments or by the costs, which would need to be repaid under CPR 44? If it is going to be extinguished, well, what's the benefit to the claimant in any event? Because they're not going to get the money. So therefore, there is no injustice in that respect. Another one is the interim payments. Can it be repaid? Now, in this particular case, actually, of Williams Henry, there was £75,000 worth of interim payments, which the claimant had already been paid, of which the claimant utilised to buy a house, purchased a house. One of the points that seemed to be considered was whether or not the claimant would have lost her house. She's got to repay the interim payments, and that's something which seems to be prevalent in this judge's mind when putting this point in the mix. It's interesting, though, however, that the defendant in this particular case didn't make a CPR 25 application for the repayment of the interim payment, and also didn't seem to suggest they would be seeking the interim payment. So when the judge was considering the factors to consider as varying the substantial injustice point, he didn't consider whether or not the interim payment would need to be repaid. It wasn't a factor that he put it into a pot. Now, what we don't know is if the claimant had to have paid that £75,000, would the judgment have been any different in relation to this matter? It's something clearly that seemed to be on Mr. Justice Rich's mind when he was considering this. And again, the final point, what's the effect on the dismissing the claim on the claimant's life? Will she have to live on benefits? Are they able to work? That's another thing to put into another point to put into the pot. So we're into another one of these positions where we look at all the circumstances of the case. But where is, in fact, in cases such as you're applying all the circumstances in Denton, for example, in a Denton case when you're looking for relief and sanctions application, quite often you might think that the prejudice seems to claimants, for example, of not putting witness statements in, seem to be prevalent in the judge's mind. At the moment, and me and Corin discussed this earlier on, we are not aware of any cases where there has been a finding that the claimant's damages shouldn't be dismissed for substantial injustice. So it's still very unclear as to when the courts might apply this test and find the claimant should still be awarded the genuine damages, or maybe a proportion of those genuine damages, because the injustice to the claimant is still too substantial. It seems that the punitive effect of Section 57 still needs to be preserved. So the jury is still out on this element in relation to Section 57.
I'm proposing now just briefly to look at some of the evidential issues when considering proving or disproving an allegation of fundamental dishonesty. A reminder, of course, it's for the defendant to prove that allegation, and the burden resting on the defendant is a civil burden, albeit some historical cases do appear to raise the bar, and certainly some of those cases would suggest that judges should start from a position and a presumption of honesty, and that the court should look at a claimant as giving probably honest evidence unless there's cogent and clear evidence to the contrary. Whatever the rights and wrongs of those older cases, my experience, it is important, of course, to bring that evidence together and, if possible, formulate your case, and so its foundations are based on clear and cogent evidence, direct evidence, if at all possible, rather than circumstantial or hearsay evidence. Not to say that a claim for fundamental dishonesty cannot be advanced and indeed proven in the appropriate circumstances where that evidence is circumstantial, and a court can properly draw an adverse inference against a claimant. But in those circumstances, it appears to me to be more difficult for a defendant to succeed where the court is balancing the potential innocent explanation for inconsistency with what might appear to be circumstantial or hearsay evidence which undermines the claimant's case and the defendant's allegation of dishonesty. A salutary reminder of the importance of the case of Guestmin. That's a commercial case, and in which Mr. Justice Leggett, as he was then, carried out a very detailed review of the adequacy of oral evidence, and that's lay evidence, and compare and contrasted ways in which that could be judged and considered as accurate and reliable. It was considered in a personal injury case of Barrow merit, and at first instance, what Richard Hamer, Queen's Counsel, sitting as a Deputy High Court judge, did was make a ruling in a case where a young claimant, young Felix Barrow, suffered life-changing injuries whilst crossing a road early morning whilst travelling to school. There was an appeal, an unsuccessful appeal by the claimant in that case. Master Barrow's case was dismissed, and the Court of Appeal carried out a review of the way in which Guestmin and Mr. Justice Leggett's review of evidence in Guestmin should be applied in a personal injury case. I always keep these four matters in mind. and they are the following. Firstly, is there objective evidence against which other evidence can be judged? And in particular, might that be used as a lodestar to judge the cogency and reliability of other evidence? Secondly, is there contemporaneous evidence? Because in my experience, courts properly attach more significance to that evidence. Thirdly, is the evidence of a claimant internally consistent? In other words, when one compares what he said through his statement or in a courtroom with other documents, has he given or has she given a consistent account? And finally, is that evidence consistent with external sources? I'll look at that very briefly in a few moments, but that might include other documents against which the consistency, therefore reliability, of a claimant's evidence can be judged. These are all important matters in nearly all cases, personal injury cases, where a claimant has to prove his or her case. But they, in my judgment, have a particular significance in cases where there's an allegation of dishonesty, and in particular fundamental dishonesty. Looking for the lodestar, that is, in my experience, objective evidence. And I set out there some examples of the evidence that might be identified by a court and might be used as a means by which other evidence can be tested. Frequently, that evidence which I've identified on the slide is used by defendants as objective evidence and therefore cogent and reliable evidence on which a court can rely when considering the honesty and reliability of a claimant's account. It's often used as a foundation, in my experience, for an allegation of fundamental dishonesty, and with good reason. Other important matters relate to contemporaneous evidence. And again, I set out some examples of that on the slide. Looking at internal consistency, in my experience, where there is a stark disparity between what the claimant said through one document with a statement of truth, or comparing that with the evidence that the claimant's given in a witness box with other documents with a statement of truth, that takes on a special and particular importance. In respect of CNFs, again, I suspect most of you watching will be familiar with Mr. Justice Martin Spencer's observations, paragraphs 7 and 8, where he rejected the claimant's submissions and found that where there was a significant disparity between what the claimant had said through other documents when compared with the CNF, that was an important matter, because the CNF was the first indication on which the claimant advanced a case on which insurers regularly rely, and of course is a document signed with a statement of truth, as indeed are all those other documents identified in the first bullet point on the slide. I look at it like this, often chronologically. And when I cross-examine a claimant or I'm making submissions, I will often take the claimant or the court through each of the pleadings, the statements, the CPR replies, the medical reports, comparing those with other evidence in the case. Are they internally inconsistent or consistent? And also, I will ask the judge to consider what was the state of mind of the claimant at the time the pleadings were signed, the statement was signed, the CPR 18 replies were signed, or when the claimant gave an account to a medical expert which he or she has instructed. What did he or she believe at the time? And then judge that against the second stage of the test in Ivy and Genting, applying an objective standard to decide whether or not the claimant's conduct is honest or dishonest. And I find that a fruitful way in which a claimant's evidence can unravel and where you can prove a claimant has given dishonest evidence. External inconsistency, as I mentioned, is an important tool in the armory of a defendant in cases of this type of nature. I set out, again, a series of types of documents, and perhaps added to those could be social media and Strava records, against which what the claimant's account given through his claim or her claim or through statements can be judged and compared. In Williams, Henry and Associated British Ports, Mr. Justice Ritchie said that DWP records and life insurance records were collateral, but they were relevant to a determination and assessment of a claimant's credibility generally, and therefore nonetheless can prove a very important way in which a defendant might undermine the claimant's case. Other ways in which that might be done might be reference to a claims history. That, of course, be twofold. Firstly, if the claimant has a long and significant history of making claims for personal injury and losses, my experience would be that judges usually look more carefully, more critically at that claimant's evidence. It might also be used as a means by which we could undermine what the claimant said to a medical expert or through his statement as to the number of accidents or claims of which he or she has had. And a similar observation can be made in respect of a trawl through medical records, which might well reveal that the claimant has had other accidents or claims which have not been identified previously. I often will look to see whether or not there's letters of instruction for previous solicitors in other claims, and that's a useful way in which one can undermine a claimant's case in respect of that matter. I think that the timing of a claim is perhaps less important for the purposes of an allegation of fundamental dishonesty. It can nonetheless be very important in case of putting a claimant to proof, but in my experience, judges will often forgive a claimant in taking their time to advance a claim, and may or may be more reluctant to make a finding that is relevant to a determination of fundamental dishonesty. Don't forget, of course, you might have the benefit of other evidence in the case where the claimant or defendant which might support, corroborate, or undermine a claimant's case. That might be relevant to the circumstance of an accident, reporting of an accident. We've had some examples I've discussed earlier where allegations of breach of duty are relevant, if disproven, to a finding of FD. We know, I'm sure, the relevance and use of social media. I would regularly recommend to claimants they take care to see that their social media accounts are closed and private. Defendants nowadays, for very good reason, would usually conduct a trawl through social media records so as to ascertain whether or not the evidence that they give through their claim is consistent with the evidence that they can be identified through social media accounts. Metadata of objective evidence, which might be used, which can undermine a claimant's case, perhaps as to the circumstances or fact of an accident. But be wary that, of course, claimants nowadays are able to digitally manipulate metadata. So therefore, its use, in my judgment, will probably become less over time. And what I find especially frustrating when representing defendants in cases of this type of nature is where a court is especially forgiving of a claimant who has been looked after poorly by a solicitor. Even where a statement of truth has been signed, and in the case of Corin, Mr. Justice Ritchie forgiving a claimant's claim where he said that the preparation of the split of the schedule of loss, which in many important respects was very different with the claimant's evidence through his statement, that didn't have a particular bearing on a finding of fundamental dishonesty. The reason for that is because it was due to poor preparation rather than dishonesty of the claimant. And where the claimant has poor literacy, might have to give evidence through an interpreter, that evidence is being translated, or indeed, as often described, the claimant may not be a sophisticated witness. In those cases, it's often far more difficult for a defendant to prove that the dishonesty exists, or if it is, that it's fundamental. Finally, that brings me on to the matter of surveillance. That could be a topic in itself. But the key issues here are when to use it, and in particular, when to disclose it. I think there is a danger that if it's disclosed and not relied upon and probably not going to make much difference, it probably doesn't help a defendant defending the case. In some cases, it can be determinative or devastating, to use an expression used by Mr. Justice Ritchie in Williams, Henry and Associated Ports, or far from devastating, as described in the case of Boyd and Hughes. But in the right case, certainly more valuable cases, it can make a difference. And the cases which Liz and I have identified today are littered with examples of where surveillance evidence has made the difference, and equally where it hasn't. When to disclose it? My experience would be that providing it's disclosed at a time where it doesn't jeopardize the trial date itself, the court is likely to allow its inclusion, even if that inclusion comes relatively late in the day. I would always recommend it's disclosed before the joint meeting between the experts, because the court may then be more reluctant to order a further joint meeting with the expense that would be necessarily follow as a consequence in those circumstances. That, I think, concludes what we wish to say today.
Thank you for joining us today.
Thank you, everybody. Good afternoon.